Hello and Jai Bhim, everyone. Today with us we have Manoj Mitta. He's a Delhi-based journalist. His focus of work has been on law, human rights, and social justice. He was a senior editor at Times of India and Indian Express, and he has also worked for India Today magazine. He has written two books which were based on impunity for mass violence. The first book was When a Tree Shook Delhi, the 1984 carnage and its aftermath. It was co-authored with Fulka. And the second book was The Fiction of Fact Finding, Modi and Godra. He has been also awarded a New India Foundation Fellowship, where his research was based on the caste-based mass violence. Today we have him here to discuss his most recent book, the third book, which is Caste Pride, Battles for Equality in Hindu India. This book was published in April 2023. We are very honored as part of Ambedkar King Study Circle to have him here. For those who are joining new, Ambedkar King Study Circle is a group based in Bay Area, California. We are a group who challenge all sorts of oppression, mostly like caste, class, race, gender, and we are trying to move towards an egalitarian society. The way we operate is by firstly having these book discussions, book reviews, and discussing books among ourselves, and being also part of the social movements by taking part in hall meetings and protests and trying to educate and create awareness around these issues. So that's the brief introduction, and I'll now pass it on to Manoj to share his insights and introduce. Yeah. Thank you.
Thank you. Thank you. I'm really honored to have been invited by an organization such as this, which, as he said, has been engaged in these caste battles. After all, my book is also about battles for equality in Hindu India. So this is the kind of people I have been researching, and in the course of which I unearthed a whole lot of hitherto unexplored legislative and judicial records relating to various aspects of caste. The way it happened was I was originally looking at the issue of mass violence. As he mentioned, my earlier books related to what we in India describe as communal violence. And the third book I wanted to be on caste violence, because in the course of my work as a journalist, I've often dealt with recurring instances of mass violence targeting Dalits in some part of the country or the other. And I've also been cognizant of the pattern of impunity, despite all the rhetoric about equality, despite all the talk about there being a special law. The 1989 Prevention of Atrocities Act is considered so stringent that some even call it draconian. So I wanted to explore this anomaly, why there is so much of impunity despite the special law. Where is it that justice is falling through the cracks, right? And in the course of that, I dealt with, say, a case like Lakshmanpur Bate. You might have heard about it. It happened in 1997. It's a massacre in a village in Bihar. I mentioned that because of all the instances of mass violence targeting Dalits, that has the highest death toll, 58, right? So, and the then President of India, K.R. Narayanan, rightly called it a national shame. And sure enough, when the trial court dealt with it, there were as many as 26 convictions, 16 of which were about death penalty. Death penalty is not something that is given casually. In India, it is reserved for the rarest of rare cases where the judge is fully convinced about the gravity of the offense and the nature of evidence available. And the remaining 10 were given life sentence. So you can see that in the perception of the trial court, it was a very serious matter, right? But then when the same case goes in appeal before the Patna High Court, every one of those 26 convicted persons was acquitted without exception. Now, the reasons that the High Court bench gives are rather flimsy. I won't go into those reasons for lack of time, but the point I wish to make is that this has been the pattern. It's happened over and over again in various cases. Lakshmanpur Bate is not an exception. And I felt that if I were to just put together all these cases of impunity, there's something very dissatisfying about it, because about such a treatment, because I can't be just leaving it to the reader to wonder what on earth is going on. So there was a need to address a deeper question. There was a need to understand where this what clearly seems to be structural bias. Where is this structural bias coming from? Hmm? Why is there such a gap between the rhetoric and reality on the issue of social justice and all that? So I therefore looked up. A logical starting point was debates in the Constituent Assembly on the question of abolition of caste. Abolition of untouchability. Yes, abolition of caste also was something that was contemplated, but it was found to be impractical and so on. But what they did take up was the abolition of untouchability and other aspects of caste, say temple entry and so on. These are all there in the constitution. So I looked up those debates, and then there were references to how these battles have been going on for a while, and it indicated, the nature of debates that were going on within the Hindu community. That's why Hindu India, I called it. There is no suggestion in this title or subtitle that the problem of caste or even untouchability is limited only to Hindus. But the nature of records, the battles that were fought during the colonial period. In fact, these battles I relate go all the way back to early 19th century. So I'm talking about material, archival material of such vintage, and they're all essentially about battles within the Hindu community, and that should actually come as no surprise, because the problem originated there. It is a system, even if it was by a different name, Varna. It's a system that originated in the Hindu religion or community or scriptures. I mean, there's a great deal of debate on whether it was meant to work this way or that way, but there's no doubting the fact that there are extensive references to Varna, Jati, and so on. And as it happens in these debates between two sets of Hindus, liberal Hindus and conservative Hindus, the conservative voices very often cited scriptures as the source, as the support for the positions they were taking, the retrograde positions they were taking, as a justification for perpetuating all sorts of iniquities and injustices, or discriminatory practices that were going on. They would cite scriptures, they would cite customs, and so on and so forth. Right. So now, what happened was, when I saw all this, I felt that there is a need for me to widen the ambit of my book rather than keeping it to violence and impunity for violence. I should shift the focus from the plight of untouchables to the legal history of caste, legal history of this allegedly religiously sanctioned prejudice, right? And that's how it's became such a thick book. That's how it became from a mere journalistic work. If I had limited myself to violence, it would have essentially been an extension of my work as a journalist. I found myself going into the domain of historians and other academics simply because none of the existing literature on the subject deals with these questions that I was trying to find answers for. The question being that why is there so much impunity? Where is this structural bias coming from, right? So they none of the existing material on the subject of caste deals with legal aspects of caste. It's only when you look at these battles that were fought over the last 2 centuries with the lens of law, do a whole lot of things come to light, right? I'll give you a few examples of some very counterintuitive information that I came across, which are figuring in this book too. Say, let's take up at random. I'm picking up somebody like, say, Motilal Nehru. You all know that he was the father of Jawaharlal Nehru, and he was president of Congress Party at one point of time, and he went on to head something known as the Motilal Nehru Committee that drafted the first set of fundamental rights. It's an initiative of several parties headed essentially by Congress. This happened in late 20s in response to Simon Commission's, the boycott of Simon Commission. It was about constitutional reforms. So Indians said that we are boycotting this commission because there was no representation of Indians in that, and we want to show that we are capable of coming up with our own, fundamental rights. We are capable of engaging in an exercise of that order, intellectual order, right? So the man who headed that was Motilal Nehru, right? And I'm now talking about an incident that took place in his life about a decade earlier. This was in the year 1913. He was at the time already in politics and a leading lawyer in Allahabad High Court. He represented a set of people who were convicted in a case of sati. They were all Brahmins. The matter went in appeal before Allahabad High Court. And the plea that those convicts took was that they should not be penalized for the reason that they were not responsible for the pyre being lit. It is something that happened automatically because of the sheer piety of the widow who was sitting on the pyre of her deceased husband. That she just willed it and it got lit on its own. This is a miracle that happened, and we can't be held responsible for it. It's a representation of, it's a demonstration of how that sati custom is divinely ordained and so on. That is the argument that they were giving, and their voice, their mouthpiece in the High Court was none other than Motilal Nehru. It's something that you would not expect, because this is a party that was leading the freedom struggle, was led to, in a big way, the drafting of the constitution. The Constituent Assembly was essentially dominated by members of this party, and it was his son who went on to become the first Prime Minister of India and so on. Right. So this is just one example of how, when you look at our material, there are all sorts of unknown, little known, counterintuitive aspects that come to light. Another example is, say, there's a man called K.M. Munshi, who is a hero for the Hindu right of today. Why? Because he was deeply involved in the struggle for restoring Somnath Temple, which was repeatedly destroyed during the medieval period. So now, he was also the founder of Bharatiya Vidya Bhavan, a conservative organization, which came up with that slogan for the first time, that India should reclaim its status as what is that? Vishwaguru, an expression that has been popularized, embraced by the current Prime Minister. Right. So there were many reasons why K.M. Munshi is a big icon for the Hindu right. But what is not known is that he was also the person who was responsible for some very interesting, reformative aspects of our constitution. One is, he is the one who was instrumental in ensuring that there is a provision for conversions. He said freedom of religion can't be only about practicing your religion. There are certain religions, and he was not talking about Hinduism. He was talking about Islam and Christianity. For them, conversions was part of their, especially Christianity. So we said you should allow, the word propagate is there in the constitution, because he insisted that for freedom of religion to be truly meaningful for all religions, propagation also should be allowed. So he was that liberal. Now, when it comes to caste, he is the one who was responsible for the original draft of the clause relating to abolition of untouchability. It was his clause, his draft that was refined, and it is in the form of Article 17 in today's constitution. Right now, more importantly, it is his draft that was, he was the one who was instrumental in uh, insisting in introducing a clause which talks about freedom of religion. In that provision relating to freedom of religion, that there should be a subclause clarifying that temples, Hindu temples, should be open to all Hindus, irrespective of caste. Now, this is not the exact language of that subclause, but in a sense, this is what that subclause of Article 25 says. Now, there is no, I mean, this is something that you would take for granted. You would think that a mosque is meant for all Muslims, a church is meant for all Christians. So why did somebody who was part of the drafting committee, a senior member, a legal expert, somebody who was part of the Brahmin community, why did he feel the need for such a provision when it came to Hindus? So he argues, in effect, that look, I'm an insider. I know how these things can work out. If you just talk about, people being given freedom of religion, among Hindus, it could be interpreted to mean that we now have the license to go back to that old restrictive practice of not allowing lower castes, of not allowing Dalits to enter temples. Why? Because they were considered polluting, and they were going to be polluting that religious space, right? So it could well mean that. So there is a need to be for a clarification in the constitution that freedom of religion does not mean that such reforms, religious, social reforms, will not be allowed. I mean, they should be enacted, and they should be given due force. I mean, they should. So this is something that was the contribution of K.M. Munshi, right? So there are so many such things that are counterintuitive. Oh, you wouldn't expect somebody from the Hindu right to be speaking like this. Now, let me give another example. This is an example from the other side. Now, the only woman Dalit in the Constituent Assembly, I don't know if any of you know, there were several Dalits in the Constituent Assembly, most famously Ambedkar, right? But there was also a woman from the Dalit community, and her name was Dakshayani Velayudan, right? Now, you would expect that she would have been, very actively involved in ensuring that all these caste-related or untouchability-related reforms that are there in the constitution, right? Most importantly, the provision relating to abolition of untouchability. Now, her role in that is very surprising. She was the only one in the in that assembly who actually opposed that provision when it was being discussed. Now, this is not a matter of opinion. These are all. This is a matter of record. It's there in the Constituent Assembly proceedings. So when this was being discussed, it was post the assassination of Gandhi, and the rest of the House saw it as a tribute to Gandhi. And when it was finally put to vote and adopted, they actually raised slogans saying Mahatma Gandhi ki jai. That was the one and only time when during those very solemn proceedings there was slogan shouting, right? Now, this is how the rest of the House saw, but they only Dalit woman saw it differently. What was her reason? Her reason was she was actually ill disposed to Ambedkar. The reason being that she was a follower of Gandhi, and prior to her joining the Constituent Assembly in 1947, she was publishing 46 rather. She was publisher of based in Chennai, and there's a book which where she clearly spells out her differences with Ambedkar, and basically her point is Gandhi had done a great deal to awaken masses, to sensitize them to the need to overcome untouchability. There may be more than an element of truth in what she said, but it was rather simplistic on her part, perhaps, to take the position during the Constituent Assembly that because of all the good work that Gandhi did, there is no need for such a provision. She was of the view that this was going to be a source of embarrassment. For all times to come, we will be showing to the world that there is this kind of an evil practice in our country. Should we be doing anything like that? She, in fact, went on to say that what the Constituent Assembly should instead be doing is adopt a resolution saying that as a tribute to Gandhi, we should all once and for all overcome this prejudice against untouchables, and that is good enough in her. That was good enough in her opinion for our country, for our society, for our religious community to get over this age-old prejudice. Right? Events showed otherwise that it has proved to be so resilient, so deeply ingrained. It has more than persisted. It has in fact escalated, right? So these are the kind of things that you see, you discover when you look at all these caste-related issues through the lens of law. No, that's the difference it has made. That's the reason why my book, by default, has come up with a surprising amount of new material, chapter after chapter. I don't make an incremental addition to the existing literature, but there's a quantum leap in each of those chapters. I dare say that because that is how it has emerged, and that is how it has been also appreciated in India and in US by academics and others, that they acknowledge. I mean, there are people here who have given their endorsements, experts on the subject, who've also um, been struck by the new discoveries that are there in this book. Now, another such discovery, since a lot of you are from Madras Presidency, I'm happy to mention this to you, that as a result of this, self-respect movement of Periyar, there was this non-Brahminical form of marriage that was adopted in a significant way in the Madras Presidency. It was called self-respect form of marriage, or Suya Maryada, right? Now, in the early 50s, 53 or thereabouts, the Madras High Court struck down the legality of that marriage for the reason that it does not conform to what is the widely accepted form of marriage, which is that it will have to be sanctified by a Brahmin priest, right? So, from the point of view of even the High Court judges, it was inconceivable that there could be a Hindu wedding, a valid Hindu wedding, a wedding was solemnized by somebody who was not a Brahmin. How can that be? That was the mindset prevailing at that time, and this is, mind you, after we attained independence, after we adopted this very lofty constitution, which is committed to the principles of liberty, equality, and fraternity. We have done away with untouchability, and so many other caste reforms are already enshrined in the constitution. But the mindset was still the old one. It was still stuck in that notion that without the role of a Brahmin, how could there be? And without it being about Kanyadan, which is about transfer of the ownership of the girl from the girl's father to the bridegroom, without it involving, say, Mangal Sutra. There are all these, there's an overlap of caste and patriarchy over there, right? So without these things, how can it be a valid Hindu marriage? That's the position, that's the retrograde position that the Madras High Court took. And at that time, the chief minister of Madras was none other than Rajaji, who, as you know, had by then been the first Indian Governor General. He was the main lieutenant of Gandhi on the question of caste, and he had long been engaged with caste issues. So one would think that he is somebody who would be very sensitive to these nuances, and who would find the position of the High Court unacceptable. But then what did he do? Under pressure from Periyar and his party, because they were all out in the streets protesting. Why? Because a whole lot of people who had been married under that system were suddenly now considered to be not married, that you were living in sin and your children are illegitimate. So that was the legal status of those marriages and those children. So there was a great deal of ferment in society, as a result of which he had to come up with some response. So what is the response he comes up with? He doesn't say, okay, let's have a bill that will legalize this, that will put this Suya Maryada form of marriage on a statutory footing. No, he doesn't do that. Instead, betraying that deep Brahminical bias, Rajaji, the great man associated with Gandhi, he comes up with a bill that calls it non-conforming marriage. Meaning he does not even give that form of marriage the respect of being referred to by what the proponents of that marriage call it. He simply calls it non-conforming. Non-conforming to what? To values of humanism? No, to the values of Brahminism. He doesn't admit that, but he says it is non-conforming. So he effectively treats it as a one-time amnesty scheme. It's like how, in recent past we had amnesty schemes from the finance ministry saying, okay, if you have black money, you come and deposit that black money. We won't ask questions. It will be legalized. So this was some kind of a one-time amnesty scheme. All of you got misled by this reformer, alleged social reformer, into marrying in a non-Brahminical way, which is actually illegal. So what we are doing is offering you a one-time amnesty scheme. You come and register yourself, and then your marriage will be legal and your children will be legitimate. But you will not commit this offense again, meaning no further marriages of this form. Now, this was found to be unacceptable. So there were protests, right? And as it happened, soon after that, he steps down for another reason relating to caste, which is that he comes up with an education scheme which says that why have our children spending 5-6 hours in school? Let us cut it by half. The remaining half, one half they study, they are in school. The remaining half, they'll go back to their homes and learn the traditional crafts of their families. If your father was an artisan, if your father was a carpenter or a barber, you come back from school and learn that skill. That should not be lost. It is important for our society. This is the notion that he adopted. Again, there were therefore protests from Periyar and his group, Annadurai. By then, the DMK party had been formed. They said, this is nonsense, unacceptable. So there was such an uproar that it was in such circumstances that Periyar stepped down. Rajaji stepped down as chief minister, and he was replaced by Kamraj, a lower caste chief minister. And one of the first things he does was scraps that education policy, that controversial education policy of Periyar. So there are such. Sorry. I'm again slip of the tongue.
Yeah.
Education policy of Rajaji. Right? They were contemporaries, that's why I keep mixing, but they were representing entirely diverse and conflicting streams of thought. Now, if I have time, do I?
Yeah.
Right?
You still have
I want to tell you 15 minutes. Okay. I want to tell you one longest story that I've been giving around around these universities. It's about, there are two streams of battles that were going on. One is anti-caste and the other is anti-untouchability. Now, anti-caste is famously associated with the great leader from the 19th century, Phule, Mahatma Phule. And then Periyar takes it up, this anti-caste, non-Brahmin movement, right? The untouchability is more of the 20th century, and the most famous person associated with it is Ambedkar, right? Now, but before Ambedkar comes into the picture, it was taken up by an unknown person. My book has one of the virtues of my book is it sheds light on an array of unsung heroes. There's enough and more focus on the freedom struggle, the struggle for political emancipation, because there the villain is the outsider, is the white man, the colonial administration. So it is very easy for us to talk about it. But when it comes to the social struggle, we sort of gloss over that. We don't, our history books don't pay enough attention to that, or those people who are fighting for social struggle do not get enough attention, because their enemy was who? Was our own elite. It was an internal enemy. It was the elite of Hindus, Brahminism, not necessarily Brahmins. A lot of them were Brahmins, but there were lots of Brahmins also, as this book shows, who were in the forefront of the reform struggle, who were themselves reformers, who were responsible for that. I mean, Munshi is one such example I just now cited, right? So there were more such examples. Now, this in March 16, 1916, there was this unknown legislator who was not even a Hindu, who was not a member of the Congress party. And that man's name was Manakji Dadabhoy. He's a Parsi, a minuscule minority, right? Now he comes up with this resolution in Parliament, or what was then called Imperial Legislative Council, right? And that was the first instance of any reference to the problem of untouchability, to the problems afflicting depressed classes, as they were called. That was an umbrella term used by the colonial administration for the people who we refer to today as Dalits and Adivasis, right? So he says that these are people who are on the margins of society. They suffer from all sorts of disabilities. We need to recognize those peculiar problems and come up with some measures that are specially tailored to meet their needs, to what he calls to ameliorate, for the amelioration of depressed classes. That's the expression he uses, right? So, and part of it was, it's high time we started collecting data on them. It is not enough to just know that they exist. Caste census was going on since 1870s. Now we also need to know what their socio-educational problems are, the kind of prejudices they face, what could be done about that. So this is the substance of his resolution. Now, by any standards, it's a very reasonable one, right? There's nobody who can take objection to that. But what do you think happened in that house? There was a vehement pushback from the Hindu right of the time. Now, who was the Hindu right at that time? It was not the Hindu right that we know. I mean, today we associate Hindu right with RSS and its affiliates, including BJP, the current political dispensation. Yeah. And they are proud to be called Hindu nationalists also, right? Mm-hmm. But we are talking about what happened in 1916. This is way before the formation of RSS. RSS came into being only in 1925, right? And yes, Hindu Mahasabha was in existence, but that was still at a nascent stage. It was still at a provincial level, right? Now, the pushback came from within the Congress fold. Congress was the big party at the time. Congress was a big tent which had all shades of opinion represented there. And it was mainly by two leaders of Congress, Madan Mohan Malviya and Surendranath Banerjee, both of who were at different points of time Congress presidents. So they were not small leaders. And Malviya had by then been instrumental in the founding of Banaras Hindu University. And he went on to become president of Congress party some more times, and also become president of Hindu Mahasabha, because these two parties at the time were acting in tandem on many issues, including the issue of caste. So now both Malviya and Banerjee took the view that this kind of a reference to untouchability in a forum like Parliament or Imperial Legislative Council was completely unwarranted. It is objectionable. This is not the place for this kind of discussion to take place. I mean, that was a mindset they had. That was the view they took. Hmm? That it was something, they even went to the extent of saying it is something that is offensive to Hindus, Hindu feelings. And this Manekji Dadabai, in his defense, says, look, I waited all these years for one of you to raise this issue. And during this period, there were very important Congress leaders like, say, Gopal Krishna Gokhale, who had been a legislator, who had passed away in 1915, a year prior to this discussion. But none of you guys all these years raised this issue. And this was an issue that was crying for attention. I mean, such an egregious form of oppression, discrimination going on in our society, and we are asking for political reforms and emancipation and so on. And what we are doing to fellow human beings, such a large percentage of people, we don't mention that at all in this forum. And I may be a Parsi, but I represent a constituency in which majority of people are Hindus. So why should I be gagged from raising this issue? That was his defense. But then the situation being what it was, the colonial administration said because of the objections raised by these Hindu leaders who were from Congress party, they urged Dadabai not to press for any voting on that resolution. They instead promised him that they would act on the substance of his resolution. And to their credit, they do follow up on that. They issue a circular to all the provinces and even attach. This is all there in archives. I mean, everything that I say, all these stories that I tell you are all properly referenced, rigorously referenced. They're all there as endnotes in the book, right? So this it goes as circulars to all the provinces, and I'll take up one province, that is Madras province, because it gives a very dramatic illustration of what followed. This was a watershed moment. This discussion that took place in Parliament, the initiative shown by Dadabai was something that ought to have been recorded in history as a tipping point, as a milestone. He was, as I said, one of those unsung heroes. As it happened, he paid a price for it. Hindu leaders at the time ganged up and ensured that he lost in the subsequent election, right? So now, what did the British government meanwhile do on the administrative front? They issued this circular, and in Madras, they take it up quite seriously. Because they give that feedback. All of the provinces were asked to give a feedback on what they did, right? So Madras one had the most impressive feedback. They come up with 3 breakthroughs. Not all of which was in that feedback. I mean, it was subsequent history, and it is for us to see, link the dots and see for ourselves what all followed on account of this very remarkable initiative of Dadabai. And Dadabai is so little known that in the books of, you'd all be familiar with Baba Saheb Ambedkar writings and speeches. That is the most authoritative source of information for researchers and others. It's a government publication, 20 volumes, right? Now, in that, there are references made by Ambedkar to this Dadabai. He was grateful for the fact that this man broke Parliament's silence on untouchability. That was a big deal. He appreciated that. He makes grateful references to him. But as it happened, he referred to him as Mr. Dadabai for whatever reason, as his contemporary. Now, these editors of the books, these collected writings, which came much later, they had no idea who this Dadabai was. So what do? They take a shorthand and they confuse him for Dadabai Nauroji. Right? So these are the kind of mistakes that you see, which is the reason why somebody like Anand Teltumre he writes in his endorsement of my book, it is invaluable, exploding many myths, restores credit to some forgotten heroes. He was obviously referring to somebody like Dada Boy, and points out errors of fact and errors of judgment that crept into some hallowed studies on caste.
Hmm.
It was a cryptic reference to this. There were other books also which I mentioned in this. Now, because of lack of time, I quickly move on to what those breakthroughs were, which Madras presidency made. There were three kinds of breakthroughs. One is institutional breakthrough. What is it that they made on the institutional front? They, for the first time, formed a body, an organization, an official organization to deal with the question of untouchability or problems arising from untouchability. So, what is it that was called? It was called the Protector of Depressed Classes. It's an office that was formed in 1919 in Madras Presidency. So this was a precursor to the organizations that came, formed that were formed later, say Ministry of Social Welfare, which later became Ministry of Social Empowerment, or you have this constitutional body called Commission of Scheduled Castes, and so on and so forth. Right? So this is the earliest prototype of such an institution meant to deal with these people. The next the next breakthrough is relating to diversity. The first was institutional breakthrough. This is a diversity breakthrough. What do I mean by that? This is even more significant. The then governor of Madras was Lord Wellington. He was prior to that governor of Bombay, and then he went on to become Governor General of Canada in your neighborhood, and then he returns to India as Viceroy of India. So he had a very distinguished career. But one very important contribution he made while he was governor of Madras went unrecorded. And what was that? He, on his own initiative, this was at a time when Congress, as I told you, had never discussed untouchability in their forum, nor even in the parliament, on their own initiative throughout that period, right? And after Dadabai raised that issue in parliament, out of sheer shame, they discuss it for the first time in 1917 in their forum, the Congress gathering that took place every year in December, right? That is 32 years after Congress came into existence. In 1917, they discuss it and they pass one mild resolution relating to that. So they were far from being bothered about any representation being given to Dalits in these legislative or administrative fora. Their excuse was, look, we are concerned with something more basic, that is fighting for the freedom of the country. So as a result, they had not yet at that stage taken up this cause. Now, at a time like that, on his own initiative, he decides that Dalits need representation in the legislature. And he recognizes the fact that there was no constituency. See, it was not a universal adult franchise that all adults above, today it's 18, can vote. It wasn't like that. You had to be propertied or you had to be educated. So it was confined to a very tiny elite section. Now that elite section was very unlikely to elect a Dalit, an untouchable, right? And this is an area where the oppression that they suffered was not just untouchability. It was also in the south. It was called unapproachability, or in some places it was called unseeability. Right? I don't know if you're aware. To drive home the point, I may tell you that a few years before that, when Swami Vivekananda set out on his Bharat Yatra, before he came to Chicago for his historic address, when he reached south, when he went to a place like Kerala, he was so taken aback by the nature of untouchability he saw there that he called that whole place a lunatic asylum. Why? Because he was familiar with untouchability, but what was happening there was unapproachability, that you don't even have to touch me. Even if you are at a certain distance, your very presence is polluting. So if I am a Nambudri, you have to maintain this much distance from that Pulaya, had to maintain this much distance from me. And if I was a Nair, because I'm a little lower in the hierarchy, the distance could be a little less. And if that man comes any closer, then he's guilty of violating that untouchability rule, and I would have to sort of go through some cleansing process and so on and so forth. So that is the kind of environment we are talking about in the southern part of India. I mean, that might come as a bit of a surprise, because in today's context, it's the more progressive part, it's the more developed part, but there's a bit of dialectics going on because it was such a bad state. That also became the place where certain very radical reforms were undertaken. And here is one reform: the that Lord Wellington nominates this man to the legislature, because that was the only feasible option. There was no question of his being elected. So he nominates MC Raja. He's the first ever Dalit legislator anywhere in British India, not just in Madras Presidency. And sure enough, in 1919, when constitutional reforms take place, Government of India Act of 1913, Montagu-Chelmsford reforms, it's called, they adopt this precedent of his, of Wellington, and they incorporate that element of nominating Dalits to legislatures. That's how Raja gets nominated afresh after the 1919 law comes into force in 2021. And several others are also, because it was not just one member, right? That happens in Madras, that happens in Bombay, and that is how in the year 1927, Ambedkar for the first time gets nominated to the Bombay Legislative Council. It was through this very reform, right? Now, as it happens in Madras, there were a group of very assertive Dalits who become legislators. So this was a provision that they created, and they did not use it for some, tokenism, to engage in some tokenism, some symbolic representation. No, they picked up really very assertive, very capable leaders, and they all seized that opportunity to raise all sorts of issues that were previously unheard of, to give voice to their community on that forum. So they raise questions, they propose resolutions and get them passed. But among them, the greatest of them, and he is completely unknown. Nobody has heard of him. It so happens that my book, for the first time, brings out this achievement of his. And what is that? No, there were references to him in some books, but nobody realized that he pulled off an incredible feat of, what is the highest thing that a legislator can do, a lawmaker can do? Make laws, right? I mean, that's more difficult, more challenging than just raising issues or passing resolutions. And somebody, belonging to this very depressed community, who comes through this nomination route, and very small minority they were in that house. So against such odds, overcoming such odds, he mobilizes support for a bill he himself drafts on the subject of untouchability, and convinces the British government that, look, there is enough support in the House. So they also support him. And that is how in the year 1926, the first ever law against untouchability is passed in Madras Presidency. Now, this is a huge achievement. It's an achievement worth celebrating, worth recording. He should have been part of the pantheon of heroes that, say, Ambedkarites celebrate, but he's unknown. That man is R. Veerayan. Now, R. Veerayan is referred to in some book, as I said. There's a book by Rupa Vishwanath on the pariah problem. She does talk about how, he is somebody who, who raised a lot of issues, who was very assertive, but somehow there's no reference to the fact that he achieved this feat of enacting a law. It's a bit like there being a book on Mughal architecture, and yet no reference to Taj Mahal. It was contemporaneously referred to as his crowning achievement. And there's an extensive, I'm a journalist who worked in an organization like Times of India. It was a different beast at the time I worked, very market driven. But during the colonial period, when it was owned by British, they were quite sensitive. I was surprised to see the space they gave to these social reform issues. They might have had their own reasons. But as Ambedkar said, it is thanks to colonial rule, these sections of Indian population, Hindu population, who were oppressed by the Hindu elite, they were getting opportunities. Ambedkar's father himself was part of the British Army. Ambedkar grew up in a cantonment area. All this happened because of opportunities that they got. So this was one such. I mean, the most important one was that somebody from the Dalit community becomes a legislator, and he utilizes that opportunity to pull off such a feat. It was not a very big law. It was a baby step, but all the same, something that for the first time treats an act of untouchability as an offense and imposes a penalty. So it was a huge, psychological effect it had. You must bear in mind that just the fact that he was sitting there. I mean, people like MC Raja, when he first goes there, because of the protocol of that body. I mean, what was revolutionary was because of the protocol of that body, an untouchable whose presence would be polluting had to be referred to, had to be addressed as honorable member. So this is all thanks to who? It is the British administration that forced this kind of reform. It was not something that was happening at the instance of Indian leaders or Indian parties, right? So are you suggesting to me that I have run out of time?
Yeah.
Okay. But I have many more things to say, but I can't complain. Yeah.
I think we can conclude with the third breakthrough.
Yeah.
And then maybe we can continue the conversation in
Thank
form
you
of question and answer.
Thank you for referring to it as a third breakthrough. What I just now described is indeed the third breakthrough. First is the institutional breakthrough. All this ensued from Manekji Dadabhai's unknown initiative, right, in 1916. So these breakthroughs were that institutional breakthrough of creating protector of depressed classes. The second was diversity breakthrough, because of which they said these Dalits had to be given a voice. And the only way they could get that voice is by nominating them. That's the diversity breakthrough. And that diversity breakthrough was not merely, a tokenism. It led to the third breakthrough, which is the legislative breakthrough. What is that legislative breakthrough? That what you for centuries considered as part of your religious way of life, religious entitlement. Look, your touch is going to be polluting to me. So that's something I can brazenly flaunt as part of my way of life. Now you are saying that it is an offense. So that is the breakthrough I was referring to. And it is evident that it is a breakthrough is evident from what Congress does when it comes to power. In post 1935, Congress forms a government in Madras, in Bombay, and elsewhere, because there was a Government of India Act which gave a greater degree of autonomy. Now the state governments could be led by Indians. So there was at that time it was not called chief minister but premier. So the premier of Madras presidency was Rajaji, the same Rajaji. So he comes up with a law, and what it was called Madras Removal of Civil Disabilities Act in 1938. Now, in history, this is recorded as the first ever law against untouchability. They don't talk about Veerayan's 1926 law at all. This is a classic example of history being written by victors. So victors here were caste Hindus. So they don't care a damn about what these lower caste people, what Dalits had meanwhile done. It is what academics call epistemic erasure, right? So when this man comes and enacts his law, that law is actually a rollback, a dilution of Veerayan's Act. Why is it a dilution? Because Veerayan's Act actually defines offenses and penalizes them. What does Rajaji's Act say? It simply says it can't get itself to treat it as an offense and penalize it, because it is very mindful, unduly mindful of the fact that this has been our culture, our religious way of life for centuries. So how can I now overnight make it into an offense? So what does it do? It simply says that any custom that perpetuates untouchability will not be recognized by courts. It doesn't say anything about it's just a declaratory law. It doesn't say anything about what would happen if somebody commits an act of untouchability, an offense of untouchability. It doesn't. It's not defined as an offense, so it's not even an offense of untouchability. So there's no question of any penalty being imposed. It's just a declaratory law, right? But the counterpart of it in Bombay, led by B.G. Kher, that does come up with a law that was more in keeping with Virayan's precedent, in the sense that it defines offences and it imposes penalties. Even so, Ambedkar and his party, by then Ambedkar, he did not need the prop of nomination anymore, because after the 1935 Act, there was also reservations for uh, political reservations for Dalits. As you know, it's a follow-up to the Pune Pact, right? So all the reserved seats were won essentially by Ambedkar's party, which was called the Independent Labour Party. They form one very formidable opposition bloc, and they oppose this bill, which is, although it is codifying offences and imposing penalties. Why do they still do so? Because of one big catch to that. Here, it is just declarative in Madras. In Bombay, the catch was that it does not treat it as a cognizable offence. What it means is, it is not an offence, though it is defined as an offence, it's not an offence over which an aggrieved party, a Dalit, can go to a police station and say, "Here, this is what has happened to me. This is how somebody behaved with me or did injury to me. So you register a case, what we in India call first information report or FIR." No, nothing of that sort was going to happen. When an FIR is registered, the police will then undertake the investigation on their own. They would record statements of witnesses and assure them some degree of protection and so on and so forth, right? So, and all the resources will be of the state, right? But now that was not going to happen. When you would call it, when you treat it as non-cognizable offense, which is what the Bombay legislation did, the bill did, it would mean that the onus was entirely on the aggrieved person, the Dalit. He would have to hire a lawyer. He would have to have the resources to pay the lawyer's fees, then get a complaint drafted and lodged before a magistrate, and then give confidence to witnesses who could have been from his community or wherever, that you can depose against these influential caste Hindus. There's so much that you are expecting a Dalit to do in that day and age. So Ambedkar pointed out that if they had such resources, probably the problem of untouchability itself would not have existed. So such were the very grudging, very reluctant ways in which these leaders, the leaders of the time, whether they were in Congress or elsewhere, were taking. In 1946, around the time of independence, the same B.G. Kher government then suddenly says, okay, we are going to be taking a bold step. In 1939 it's opposed, so it was dropped at that time. In 46, around the time of independence, they say we are taking a bold measure. What is that bold measure? We are now going to make it a cognizable offense, right? So what was the minimum that needed to be done? They considered it a bold measure, but then you can see their reluctance even after independence, even after the abolition of untouchability. So I'll just give me 2 minutes and I'll end after that. I promise you, right? So what is that untouchability? That's Article 17 say, untouchability clause in the Constitution. It says, okay, this is this is no more going to be tolerated. This is an offense, and it will be penalized, right? So for that clause to have teeth, for it to be enforced on the ground when any offense is committed, it was meant to be followed up with a law. Till there was a law in which all these things are enumerated, all these offenses are defined and penalized, there is nothing. It's just a declaration. It won't have any meaning, right? Now, the Nehru government showed no hurry in coming up with a law to fulfill the commitment made, the compact made in the Constitution, right? In fact, I may add that Nehru himself did not participate in any debates relating to untouchability or any of those caste reforms in the Constituent Assembly. He was not necessarily casteist, but he was somebody who took the view that the caste is subsumed in class, and if I address the challenges of modernity, somehow all these primordial aspects of our society, Brahminism or untouchability, they would all be erased. That's one way of looking at it. Another way is, look, you're talking about a prime minister who had no qualms about being addressed as Pandit Ji or Pandit Jawaharlal Nehru. So maybe he was a closet casteist. Now, you have to consider what happened in 1954 when this bill was finally introduced. 4 years later, more than 4 years later, the Nehru government finally introduces the bill. And it is through Home Minister. Even in that debate, Nehru does not participate. The Home Minister was Kailash Nath Kadju. Now, he makes no pretense of his reluctance about being associated with that. Though he was piloting the bill meaning he would have to now sell that bill to that house, right? So you sing the virtues of that bill. Instead, what this man says is, this is actually no way to go about it. This kind of problem is about attitudes, is about something that is there in our deeply ingrained in us. So if you lock up somebody on the issue of untouchability, then what would happen? His feelings will get hardened. When he goes there, he will begin to hate untouchables even more. So when he comes out, it's not going to resolve the problem. So let's not go this route at all. Let's not go down this path because it will not work. What we should instead do is adopt the Gandhian approach, which is what, if you recall, what I said about Velayudan, Dakshayani Velayudan. He was actually speaking her language. Let's adopt the Gandhian approach of appealing to people's hearts. Let's try and change their feelings, their hearts. And so this man, he was preparing a ground for justifying the very mild offenses that his bill provides. Mild offenses, mild penalties. It says that if somebody is found to be guilty of untouchability, no matter how grave the offense is, the maximum penalty would be 6 months imprisonment. And it doesn't say and after that. It says or a monetary penalty, which means that, and there's no limit for the lower limit for that monetary penalty. So it says, Ambedkar pounces on this man, and says this is something that cannot be allowed to go unchallenged. He has made it so clear that his heart is not in it, and this is no way anybody should be piloting a bill. I mean, he is not actually telling us why the bill should be voted, for. He is instead being so apologetic about it. It appears that he himself wants to commit an offense because he's provided such a mild penalty that tomorrow, if the judge is some Brahmin from Varanasi of a very conservative bent of mind, he might say, okay, offense is established, but I have the leeway, the freedom to impose just this much penalty, which is, since there's no lower limit, I don't need to resort to imprisonment because there's an alternative penalty provided, which is monetary penalty. And there's no lower limit. So I can just give 1 rupee fine and let him get away with it. So this is the kind of farce that was going on. And this is going on in the early years of our republic. And soon after the freedom struggle, soon after Gandhi passed away, there were lots of great things that happened. I mean, Nehru administration rightly gets credit for laying the foundations of our democracy, for nurturing institutions, for creating IITs, IIMs and all that, right? But there was also this aspect that on this crucial issue of caste, it was so deficient. And this is what shows, I began with by talking about how my original idea was to do a book on violence. And I saw that there was so much impunity for it. So where was this structural bias coming from? So this whole exercise of my going into the legal history of caste showed to me, or conveys, that today's fault lines can well be traced to these unfinished battles of colonial vintage or of our early years of our republic. If somebody like Nehru's government showed such reluctance at a time when we would expect our country to have been very idealistic, all those freedom values still fresh in mind, at that time itself they were so reluctant on the question of combating untouchability, right? So what kind of determination can you expect from judges and lawyers and police of today to render justice to the victims of untouchability. I think I've spoken enough. Thank you very much.
Thank you.